Imagine getting a legal letter in the mail telling you that your 16-year-old daughter, a teenager who worked at a bakery for 1 month frosting cupcakes, is now legally forbidden from working anywhere that sells baked goods for the next 2 years. Not a high-level corporate executive, not a chef with access to secret recipes, a 16-year-old with a frosting spatula. And the kicker? She didn't even quit. They fired her by text message. This actually happened, and what this family discovered when they started digging into that letter is something every parent, every teenager, and frankly every worker in America needs to hear before they sign anything at their first job. Let's talk about what non-compete agreements actually are, why companies use them, and why sending one to a fired teenage bakery employee is not just absurd, it might actually be completely unenforceable and possibly even illegal. Non-compete agreements, sometimes called restrictive covenants, are contracts that employees sign, usually at the time of hiring, that restrict what kind of work they can do after they leave that employer. The idea behind them, at least in theory, makes some sense in certain industries. If you're a software engineer who just spent 3 years building a company's proprietary algorithm, your employer has a legitimate interest in making sure you don't walk across the street and immediately hand everything you know to their biggest competitor. If you're a senior sales executive who has relationships with every major client, a non-compete might protect the business from losing those relationships overnight. That's the theory. In practice, non-compete agreements have been used aggressively and often abusively against workers who have no real trade secrets, no specialized knowledge, and no meaningful competitive advantage, just a job they need to pay their bills. Sandwich shop employees, hairstylists, security guards, and apparently teenage frosters at franchise bakeries. The family at the center of this story lives in Michigan. Their daughter had just started her first real job at a local franchise bakery location. She was 16 years old, still in school, and she was hired to frost baked goods. That's the job. Put frosting on things. It's skilled in the way that most food service jobs require skill. You learn the recipes, you learn the presentation standards, you show up on time, but it is not exactly the kind of position that generates proprietary trade secrets. At some point during her first month of employment, she signed a stack of new hire paperwork. This is completely normal. When you start any job, you're handed a pile of documents, tax forms, direct deposit information, employee handbooks, safety policies. You sign them, you hand them back, and you go clock in. Most adults with years of work experience don't carefully read every document in that stack. A 16-year-old on her first job? Almost certainly not. Buried in that stack was a non-compete agreement. The family described it later as extremely vague. It didn't specify particular competitors, it didn't describe protected trade secrets or proprietary processes. It just broadly stated that the employee could not work for any company that sells baked goods for a period of 2 years after leaving employment. Any company that sells baked goods for 2 years. Think about what that actually means in practice. That would include every grocery store, every coffee shop, every restaurant that has a dinner roll on the table, every diner that serves pie, every gas station with a packaged muffin near the register. Under the literal terms of this agreement, this teenager would be locked out of a massive portion of the entire food service industry, one of the most common places where teenagers and first-time workers find employment, for 2 years. And then, after less than a month on the job, the manager fired her. Not in person, not with a formal meeting or any kind of documentation review, by text message. She was let go over text, and a short time later, her family received a letter in the mail from the corporate franchise operation with a copy of the signed non-compete and what amounted to a reminder that she was bound by its terms. Let that sequence of events sink in for a moment. This company fired a teenager via text message and then sent her family a legal-sounding letter warning her not to go work somewhere else. She wasn't even looking for another job at that point. But the letter arrived, and suddenly this family was sitting at their kitchen table, wondering whether their 16-year-old daughter was actually in legal jeopardy for frosting cupcakes. The mother immediately did what a lot of us would do. She reached out to the company and the corporate franchise headquarters to express her concerns. And then she started researching. Because something about this entire situation felt deeply wrong, and she wanted to know whether the law was actually on their side. Here's what the law actually says. And this is where things get really interesting for anyone in Michigan, or honestly in most of the country. First, let's talk about minors and contracts. In virtually every state in the United States, including Michigan, contracts signed by minors are considered voidable. That's a specific legal term that means the minor, not the adult or the company on the other side, has the right to cancel the contract. Adults are generally held to the contracts they sign. Minors are given special protection under the law because society recognizes that teenagers do not have the same legal capacity, life experience, or bargaining power as adults. So when a 16-year-old signs a non-compete agreement, she likely has the right to simply disaffirm that contract. To say, I was a minor, this contract is void, and I am not bound by it. Second, even if she were an adult, Michigan has specific laws governing non-compete agreements, and they are not friendly to agreements like this one. Under Michigan law, non-compete agreements must be reasonable in scope, duration, and geographic area. They must protect a legitimate business interest. Courts in Michigan have repeatedly struck down non-compete agreements that are overly broad, vague, or that don't actually protect any genuine business interest. An agreement that bars a frosting employee from working anywhere that sells baked goods for 2 years, with no geographic limitation, no specific competitor list, and no identifiable trade secret to protect, would face serious problems in any Michigan courtroom. This is the kind of agreement that legal professionals would look at and immediately identify as almost certainly unenforceable. Third, there's the question of consideration. In contract law, for an agreement to be valid, both sides have to give something. If this agreement was buried in standard new hire paperwork, and the employee received nothing beyond the job itself in exchange for signing away her right to work in an entire industry, courts often look skeptically at whether the agreement has adequate consideration to even be enforceable. And fourth, and this is arguably the most important point for working people to understand, even an unenforceable non-compete can cause real harm if workers don't know their rights. Companies send these letters knowing that most recipients won't consult a lawyer. They send them knowing that the letters sound authoritative and scary. They send them knowing that a 16-year-old and her parents might simply assume the company has the power to do what they're claiming. The letter doesn't need to be legally valid to be effective at intimidating people out of getting new jobs. So what should a family do when they receive something like this? First, do not panic. Receiving a letter is not the same as losing a lawsuit. Second, consult with an employment attorney. Many offer free consultations, and in situations involving clearly questionable non-competes, an attorney can often send a brief response letter that makes the problem disappear quickly. Third, in Michigan specifically, filing a complaint with the state attorney general's office is absolutely worth considering if you believe a company is using abusive or deceptive practices. The AG's office has consumer protection functions that can investigate whether a business is systematically intimidating workers with unenforceable contracts. The Better Business Bureau is less legally powerful, but can create a public record that other families might find useful. Fourth, and this is the lesson that applies to every single person watching this, read every document before you sign it. This is genuinely hard advice to follow in the real world because employers create environments where questioning paperwork feels uncomfortable or even threatening to your job offer. But it is always acceptable to ask for time to review documents. It is always acceptable to ask what a document means. And if an employer tells you that you must sign everything immediately with no time to review, that itself is a red flag worth taking seriously. For teenagers especially, parents should have a conversation before the first job about what new hire paperwork typically looks like and what kinds of clauses to watch out for. A non-compete agreement is not standard practice for entry-level food service work, and any teenager who encounters one should bring it home before signing. The family in this story did the right things. They contacted the company, they researched their rights, they shared their experience so other families could learn from it. And most importantly, they didn't let a threatening letter from a corporate legal department convince them that their daughter had done something wrong by taking a frosting job. She hadn't. She just needed a summer job. They fired her by text, and then they tried to scare her family with a piece of paper. If this happened to you or someone you know, if you've received a non-compete letter that seems wildly out of proportion to the job involved, especially involving a minor, talk to an employment attorney in your state before you do anything else. Don't ignore it, but don't assume it's enforceable either. The law has real protections for workers, and especially for young workers, but only if you know those protections exist. If you found this video useful, subscribe so you don't miss the next one. We cover real legal situations that real people face every day, because knowing your rights isn't just for lawyers.